My lord, I am seeking lordship indulgence to leave the matter, if possible, my lord, idea, my lord. Or it is fresh case, my lord.
When did you file? It's a new case.
New case, my lord.
Did you file?
My lord, it is once it was listed, but because of some inconvenience from our party, it could not be done, my lord.
Right. Amendment. Okay.
My
Lord, I have a humble request to make, Lord. With your Lordship permission, this matter is listed today. Item 44 is the order list. I have filed an IA for release. The person is in detention. Can it be taken away to me, Lord?
Before rising, we'll take up.
My Lord, I am deeply.
May I please, your lordship? My lord, I beg to mention item 43, my lord. Orders matter, my lord. I have for correction a single word, my lord. It
That
would
too.
be, my lord.
Like similar prayer, my lord. Correction of the order, my lord. Only just application number will be inserted.
Is it
Item
listed?
22 and item 42. Obliged.
May I please, I beg to mention for listing on motion matter, my lord. Earlier, my lord, 16/9/2024 listed, but due to paucity of time, my lord,
Friday.
Friday, my lord.
No,
One more, my lord, one IA, my lord, for correction, my lord. District, my lord. Instead of Baksha.
Tomorrow.
Lordship, I beg to mention item number 24, lordship. In this case, lordship, I am instructed to appear for respondent, lordship. Today, I am going to file the affidavit. So, Okalatnama, lordship, may come after vacation, lordship.
Let the matter reach, we'll pass the order. Okay.
Maybe I beg to mention for listing of order matter, minor correction matter, jurisdiction, my lord, SP, my lord. It was,
When did you file?
my lord, it was early filed, my lord, the order was first, my lord. Your lordship passed the order, intim was first, my lord. But subsequently, we have come to know that the petitioner district, officially, my lord, the petitioner belongs to the Bozali. Order was passed Bozali, but now they say that you will case SP Borpata, my lord.
Tomorrow.
Hello, Blashman.
May I please, your lordship, item number 37 was listed in this code, but it may not be listed because your lordship was advocate in this respondent side. So, diploma.
May I please, your lordship? I beg to mention item number 2, lordship.
Item number?
2, lordship.
What's
My
the prayer?
lordship, my senior is having some personal interest passed up today. So can it be finally passed over for the day?
Let the matter reach.
May I please, your lordship? I beg to mention for listing one IA, but for extension of time to appear before the
When the order was passed.
order was passed 29/5, my lord.
So,
29,
why should you consider?
my lord, due to lack of communication, my lord. could
That
not-
cannot be, because in order was passed in May.
Earlier,
Today we are in the end of September.
earlier in 2018, he is already appeared. Subsequently,
Definitely.
fresh bill was granted, my lord. Kindly, my lord.
Day after tomorrow.
Obliged.
So I beg to enter item number 27, lordship. If I'm paying for adjournment only for today, lordship. Personal difficulty.
So if you adjourn it today, it will not come this week. Or the next week.
Next week, lord. After vacation, then. Lord.
There are matter. Council. Matter be adjourned for today. Next on 23.
Obliged, lord.
Three to be spoken to. Mr. Nath,
My
incident occurred in 2013,
13.
right?
Yes.
What was the notification for payment of any such compensation during that period? Can you tell us, we'll pass the order day after tomorrow. You verify, you have given us only we have the 2017 notification.
Well, the 15, 11,
But
2014.
there was
At that point of time,
a
possibly 6,
notification of
2006.
15, 11, 2014 and 26, 12, 2014.
Lordship.
Now, what was
Prior to
during that point of time?
prior
you
to
want to know?
I'll check up. I'll
Right.
check up.
And,
Possibly 2006 was there. I'll check up.
Tell us
I'll tell you.
whether in 2014 notifications, both the notification, it was given in a retrospective effect or not. Tell us. What was there in 2006 or 7, whatever.
No.
You tell us.
I'll check.
Along with the notification.
Lord.
Pending.
Malad. I'll check.
And we'll take up that matter at 10:30. Also
Sure.
have the notification set.
Right.
2 sets of notification for both.
My lord, I have brought some citations of the Honorable Supreme Court. Honorable Supreme Court in various judgment had expressed anguish that a person is killed and the High Court has taken the matter lightly. Supreme Court has ordered unfortunate on the part of the High Court that it was not taken. Moreover, there are also observation that the case is the police tried to shield out their own persons. So the party is at liberty to challenge that charge because police has got ample power. They can file.
What do you want to say?
My lord,
What do you want?
I want to say that the judicial inquiry, that was our prayer. Through this
We'll look into that. We have not yet disposed of the matter. That's why it has been listed today for to be spoken to. Okay?
judicial inquiry, plus inquiry at the police that in which case FIR has been filed, that should be investigated by high-ranking police officer. Thirdly, heavy compensation.
It will come up on 24, 26. Sorry, on
26 is 27. Lordship.
take it up at 10:30. You have the notification.
Malad. I'll get that.
Well, if your last revision compensation part of 86, at the time, that is in the year 2013, that, at that time they did not pay. So we will expect that some interest.
See, you have not yet passed the order, Mr. Mahmood.
No, that is my expectation. Of life. 27. On that day, I may file citation chief necessity arrangement. So many judgments I have collected.
And that day, give us a copy of your protest petition.
Malad, we will also make our submissions whether the compensation is payable under this particular fact and circumstance.
No law is
No.
necessary.
No,
A
fine.
person is killed, that is enough.
No, person died
We are
because of
taking
his
up
own
different matters,
negligence.
Mr. Mahmood.
I'll
We are only
submit.
in item
Lordship.
number 1.
Lordship.
May I please, Lord? My lord, the petitioner exhibited, my lord, voter list of 1966, 1917. And my lord, her name has been recorded in the voter list of 1989. And my lord, she examined as many as 3 DWs. including herself as DW1, younger brother DW2, and Gaubra DW3. my lord. And your lordship will
There is
find
an
that-
order passed earlier
Yes, my lord.
on 15th of March 2023, right?
Yes, my
So what do we have to submit?
lord. Let it come after vacation. In the meantime, I will file an additional application. And
Matter is pending since 2019.
19, yes, my
To
lord.
you,
Last order was, my lord, 15/3/2023. Yes.
Yes, sir.
please take it. Yeah, I'm not coming.
My lord, may I pray one thing, my lord? My lord, he is not in interim, my lord. He is not in interim, my lord. Yes. Oblige.
Yeah.
Please চালাচ্ছে
Yes, doctor.
Yeah.
Nineteen 92. No, I know, no, just a second. Mother and brother. Not permissible lot. Faulty reference logic. It can proceed only against whom the inquiry has been done, Lordship. Calling for all three records. Yes, Lordship.
I suck mark.
Faulty reference to it will
Independent.
Hmm.
Lordship,
Need it.
yes, Lordship.
63, Lordship. It is.
Yes, Lordship. Yes, yes, Lordship. Yes, Lordship.
Yes, Lordship. We'll get this confirmed. Copy diba aji? It is 60 or 62. Yes.
Yes, yes. Yes, Lordship. Yes, Lordship. Yes, Lordship. Yes, Lordship. Monday, Lord.
Lordship, I am not available after Saturday. My friend will appear on next week, Lordship.
Lordship, Lord. Friday, no, not possible. Monday, Lordship.
We'll get it, Lordship. We'll
Lordship.
check. We'll have it.
Otherwise, Lordship, next Thursday, Lord.
Okay.
Lord.
There's a motion week also, Lordship.
Yes, I will get. Lordship, Monday, I will get it, Lordship. Next Thursday, Lordship. If required, Lordship may take it as first item, Lordship.
Yes.
Lordship may kindly allow me to see the record for the time being. Record, Lord. Record. Yes, yes. Yes, Lord. Yes, yes.
May I please, your lordship? My lord, the petitioner exhibited, my lord, voter list of 1966, 1971, where his father's name has been recorded. And my lord, 1985 voter list, his name has been recorded along with his father, my lord. My lord. Reason, my lord, these documents are not believed, my lord. And some documents were not at all discussed, my lord. The lordship will find the opinion at page 126. And one documents, my lord, school certificate, exhibit 6, my lord, that was, my lord, the authenticity was, my lord, proved, my lord. The headmaster of the said school was deposed as DW3, my lord. But the record may be called for, my lord.
Records are here. Records are here.
Notice is not yet issued.
Certificate has the emblem. Therefore rejected.
No, but the headmaster was deposed. The headmaster, my lord, he was deposed.
But on a certificate which is not acceptable.
Lordship, there are two reasons. If Lordship may kindly come to the opinion, Lordship. At page 131, Lordship, where the exhibit, where the school certificate has been discussed. It is at exhibit 6.1. He also deposed, may I read from page 130, Lordship? Paragraph 9.1, Shiba Upadhyay, headmaster in charge of so-and-so, has appeared before the tribunal and reduced his evidence as DW3. He has proved
You
the
are reading
exhibit
from page 131.
130, last paragraph, paragraph serial 9, Lordship. The headmaster in charge appeared and adduced evidence as DW3. He has proved the exhibit as the certificate issued from their school. He has also identified the seal and signature of the then headmaster. And so he has also deposed that he brought the school admission register since the year 55 to 84, which is produced at exhibit A, and the page in which the name of Muhammad Abdul Salam is shown to be registered. He has deposed in his cross that in the admission register, it is not mentioned on the basis of which document the age of the student is mentioned at the time of his admission. In the record of the school, neither any birth certificate, nor any horoscope, nor any application filed by the father of the student is available. He does not know the proceedee personally. The admission register which he has produced before the tribunal is completely torn out. He tried to match two pieces of a page of the said admission register, presuming both the pieces are the pieces of the same page. But again, serial number 37, the student is shown to be admitted on 11/3/67, whereas in the other piece, in the column of the signature of the headmaster, the signature is shown to be put on 6/3/2007, from which it is established that both the pieces are not the pieces of the same page. Therefore, the information given by him are not correct. The correct information in respect of Abdul Salam cannot be traced out from the said torn out admission register. Since it was produced before the tribunal has examined it, so more than this, I don't think any discussion is required, Lordship.
No, he was born, my lord, in the year 1962. And the birth certificate concept was not at that time, my lord.
No, on the,
Now he can produce the birth
on the
certificate.
evidence which is discussed, tell us where is the permit? It's extensively discussed. Even though the certificate contained the envelope.
Okay. That is, my lord, not fault on the part of the petitioner.
In 67, Lordship,
that-
was this emblem used? Now, if my friend is saying he was born and he does not have a birth certificate, we will have to look into documents of that time, whether this state emblem was used in certificates at that point of time.
That was
Or it's
their
a recent certificate and it has been, the information has been put in just for the purpose of the reference, Lordship.
And my lord, his name, my lord, has been recorded in the voter list of 1985, along with his father, my lord, parent, along with her parent. Yes, my lord, 27. These documents are not considered.
Page 27, the voters list which my friend is referring to, Lordship, it has the name only of Salam, not Abdul Salam.
Yes, Salam and Abdul Salam is same and
How
one
can you
person.
be
That is
saying-
also discussed in the WS
How
also,
can you say it is same?
as well as in written evidence also.
Your statement. Lordship,
How
at
do you
page,
explain, how do you explain the appreciation of evidence at page 132?
Yes, 132, my lord. One 32, my lord. Para 11, my lord.
No, no, before that,
It is seen
end
that
of,
in.
end of para 10. Yeah,
Yes.
that is it. It is
My
seen
lord,
that.
it is seen that in the said document, the name Salam, son of Mofizuddin, is recorded as voter. In the said document, the names of another two sons of Mofizuddin are also recorded as voter, namely A. Sattar and Abdul Hakim. The proceedee has deposed in his cross-examination that they are four brothers, namely Abdul Mutlib, Hussain Ali, Abdul Salam, and late Abdul Sattar. But he has not mentioned the name of Abdul Hakim as his brother. Since in the exhibit 13, the name of Abdul Hakim is the recorded as voter as son of Mofizuddin, and since Abdul Hakim is not the brother of the proceedee, therefore the father of the Abdul Hakim, namely Mofizuddin of village Patasimulo, is also may not be the father of the proceedee. My lord, kindly come to my lord. Evidence of BW1, my lord. Page 91, my lord.
Your father's last name appeared last in which voters list?
My lord, 1985, my lord. His father expired, my lord, 2000.
2000.
1000.
Hmm. My lord, after 1985, my lord, the petitioner shifted to my lord Gulaghar. And after 85, his only voter list has been exhibited. 97, 2005.
But father remained in Dhekiajuli.
Yes, my lord.
So his name probably should have appeared in that voter list. 97 voter list.
But that, no, my lord, 1997 voter list, my lord. Then he was at Gulaghar. He,
Petitioner was at Golaghat.
yes, my lord. His
Petitioner-
father voter list has not been exhibited.
Where is his father? Where was
Father, my lord, he was in Dhekiajuli, Dorong district. 1988, he was shifted in the year 1988.
if you come to page number 27,
Yes, my lord. 27, voter list of 1985, my lord.
Ah.
Mofizuddin, father, Saitonnesa, mother,
Hmm.
and Salam, my lord.
Salah.
Abdul Salam.
Your age
Abdul
is
is not there.
24.
Salam.
Your age is 24.
Yes, my lord.
So your date of birth, year of birth will be around 1961.
62.
1961.
61 or 62, my lord. Yes.
If you come to page number 29, there your name appeared along with your wife.
Wow.
97, my lord.
97,
97, 39, my lord.
39.
39.
So your year of birth will be 1958.
Age discrepancy is there, my lord. Some discrepancy is there, my lord.
Then
That is
you come to page number 30. This is 2005,
47.
47. All right. But look at the name of your father. Mofisardin Salah.
That was, my lord, discussed in the WF. Wrongly written as Mofisuddin Salam. That is there in the WF.
Where in your WS?
My WS at page, my lord, 51.
Where is it discussed?
My lord, para 20, my lord, 20, page 57.
No, that is for the voter ID.
Yes, my lord.
But in the voters list, come to page number 53. Para 10.
The office father actually name is Mofizuddin Sheikh, but in the voter certificate copy of the year 1971 and 1977, it is recorded as Mofizuddin and Hafizuddin.
Hafizuddin.
Hafizuddin. This shows negligence of the official authority while recording the name, because in the voter certificate copy of the year it is correctly appeared as Mofizuddin. But in the year 1971, certificate copy it is mentioned as Mofizuddin.
And in the subsequent voter list, it is Mafisardin. Salam.
Mofizuddin, yes, my lord. And 1966, my lord, it is correctly recorded, Mofizuddin. The names which were recorded in the certificate copy of the year 1966 are also recorded in the certificate copy of the year 1971. But only the name of his father is wrongly recorded, and also the age of the family members, because the age which are recorded in the year of 1966 is also similarly recorded in the voter certificate copy of the year 1971. These discrepancies are there.
Then
Some
where is the
did-
infirmity? of the tribunal's order.
It is also the negligence of the official authority, not the OP, and the name of the office father recorded in the year 1977 as Hafizuddin instead of Mofizuddin.
No,
There
you
is
are,
no-
you are challenging the order of the tribunal. You have to point out the infirmities in the order. You point out the infirmities that this particular evidence was wrongly appreciated, not appreciated, as shown from the records.
Only they discuss in the WS and my lord in written evidence. These days. And my lord,
Your main thrust of the primary document school certificate has been explained in detail why it was not considered. It
my
is
lord,
not
the
your case that
headmaster,
it is not your case that the discussion of the school certificate is belied by the record.
the headmaster deposed that these two pages are different pages.
Page
Not the
100,
same page.
Lordship.
But
Lordship.
he himself, my lord, how he know, my lord? the
He's
present
only
petition.
32 years.
That records were, my lord, kept in the custody of the headmaster.
No,
or
no, he brought the record. No? The records do not indicate how your age was entered in.
Page 100 is clear, Lordship, where the tribunal has put questions, Lordship. May I read it. As per law, we are not authorized to print the state emblem at this certificate. In the admission register, it is not mentioned on the basis of which document the age of the student is shown as 5 years at the time of admission. In the record of a school, neither any birth certificate of the student nor any horoscope nor any application filed by the father of the student is available. I had been serving as assistant teacher of the said school since 1st June 2012. I do not know the proceedee personally. The admission register which I have produced today is completely torn out. I tried 2 pieces of the page of the said attendance register, presuming both the pieces are the pieces of the same page. But since again serial number 37, the student is shown to be admitted on 11/3/67, whereas the other piece, the signature of the headmaster is put on 6/3/2007, from which it is established that both the pieces are not the pieces of the same page. Therefore, the information given by me are not correct. At this stage, from the said torn out admission register, the correct information in respect of Mohammed Abdul Salam cannot be traced out. In the attendance register, no any name of Abdul Salam is shown to be enrolled in the month of September 1968, and I propose copy. Lordship, in one voter's list, he claims to be Salam. Then he says, I'm Abdul Salam. And then the document says Mohammed Abdul Salam. His own name has 3 different uh, versions, Lordship, and the father's name is already there with four different names. Not a single document shows his linkage with his father, Lordship.
page 33, my lord. প্রমাণপত্র দেয়া হয় যে মোহাম্মদ আব্দুল সালাম, পিতা মোহাম্মদ মফিজউদ্দিন, গাঁও ফটাহিমুলু, ডাকঘর ফটাহিমুলু, থানা ঢেকিয়াজুলি, মহকুমা তেজপুৰ, জিলা শোণিতপুৰ, অসম। তেওঁ ফটাহিমুলু ব্লক প্ৰাইমাৰী বিদ্যালয়ত পঢ়িছিল। ইংৰাজী তাৰিখে এই বিদ্যালয়ত তেওঁৰ শিক্ষা শেষ হ'ল। এই বিদ্যালয়ৰ তৃতীয় শ্ৰেণীৰ শেষ পৰীক্ষাত তেওঁ তৃতীয় বিভাগত উত্তীৰ্ণ হৈছিল। বিদ্যালয়ত থকা কালত তেওঁৰ স্বভাৱ চৰিত্ৰ ভাল আছিল। ইংৰাজী 2006 চনৰ ডিচেম্বৰ মাহৰ 12 তাৰিখে তেওঁৰ বয়স ভৰ্তি বহী মতে 44 বছৰ 10 মাহ 11 দিন হৈছে। Page 24. Yes, my lord. Yes.
307. Yes. Okay. Full service.
My lord, this matter may come up after vacation, my lord. I will place some judgment, my lord. Regarding the name and age discrepancy, my lord. After vacation, my lord. And I will raise, I have to go.
Yes, I want to place a judgment on serving affidavit. Lying on lordship, 2018 1 GLT 372. 1 GLT 372.
My lord,
372. Lordship, it is regarding the discrepancy with the voters list. The contended were not her creation being entered into by official election commission and therefore should not be used adversely against such contention is without any substance. The voters list were reduced as evidence by the petitioner herself because she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portion of the voters list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document is put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. The second one I want to rely on is
Okay, can
my
you
lord,
give us the
let it
name of the
come on
party?
other day, my lord. I have also, my lord, more point to raise, my lord.
India. Barcelona BB. Next one is on self discrepancies in the name of the father and grandfather by spreading an affidavit. Such a self-serving flow motor affidavit is neither good, it is neither proof nor evidence having regard to the provisions. Doctor, this is this time we have, WPC 3547 of I'm relying on this code, Doctor 3547 of 2016, Mohammed Babul Islam, decided on Doctor 9/5/2018. Paragraph 23 and 23 law. That's it. And surgery is
My lord, let it come on another day, my lord. I have raised some more points, my lord, and I have to go through the record, my lord.
No, but
Or
why did
fix
you
a date,
not,
my lord.
we were hearing the matter. If you wanted some
But
judgments
this
to
is
be
my
placed.
today's motion day, my lord. It is listed in motion, my lord. My lord, my lord, let it come after petition. Before 31st, my lord. Oblige, my lord.
May I please, your lordship. My lord, this petition preferred against the ex parte opinion, my lord. And eventually, no notice was served upon the petitioner. And therefore, my lord, on last occasion, LCR was called for, and LCR already been received. And LCR also reflected that eventually no notice was served upon the petitioner proceeding, and everything was proceeded against the wrong address. Because two villages is adjoining, one Pukarpar and another Khongra. And the verification report submitted by the electoral registration officer of 46 number of Surukhetri constituency and showing the village of the petitioner as Pukarpar. And eventually the petitioner is inhabitant of village Khongra, which is under my lord, Senga constituency, my lord. And district is same, my lord, but their address is found different and different constituency. And therefore, no notice was served upon the petitioner. Now petitioner, my lord, come to know regarding this impugn ex parte opinion. And after receiving this certificate copy and approached before this honorable court, saying that he is ready to contest the case. And if the honorable court allow to remand back this case by fixing a date to appear.
Why did you not file a review?
But,
When were you informed about the order?
this copy, my lord, certificate copy received on,
No.
I have narrated under paragraph 11, my lord. Under para 11, I have narrated, and this copy received, this certificate copy received on 22nd of May, 22nd of May. And before this read, my lord, to allow, I am ready to contest, my lord. Everything was beyond my knowledge. And the impugn expert opinion also saying the notice was not served. And saying that Gaura stated that proceeding is not available in the said village. If not available, how he can receive the copy? And so far, my lord, the voter list is concerned. No, sorry, my lord. The electro identity proof. Here his address shown, Village Kongra, PS Tarabari district, Borpeta, my lord. And his father's name shown as Faizuddin Sheikh. And Faizuddin Sheikh's name also appear in the voter list of 66, that is page 23.
It's been shocking. Lordship, the order sheet of Lordship comes to page 20. The Gavbura was summoned, Lordship. Order dated 15 to 2020. Case records is put up on being perusal of the report of the process survey. It appears that the Gavbura, Ramesh Ali so-and-so, he refused to give information in the manner of certificate against the suspected proceeding. Being an Gaubura, it is the duty to give information before the tribunal court as and when required. Apart from this, the Gaubura has come before the court and stated that he is ready to give information in manner of certificate. But the Gaubura neither appeared nor submitted certificate in this regard. On the other hand, the Gaubura also stated he is an old aged person and ailing one. After waiting a long time, the Gaubura did not obey the order did not obey the court and tribunal and avoided the matter. As such, this information has served upon you is if he is not unable due to old age and ailing, necessary action should be taken for this smooth performance. Copy forwarded so and so. In his presence, the notice was hanged. He was very much aware of the proceeding, Lordship. If the address is same in the reference and when the process server goes, and even in the proceeding before the tribunal, only when the notice is served, Lordship, they always, most of the times they are missing. Sometimes, if Lordship looks at the first order, it says case record after how many times the process server went, Lordship, it is written there. I just checked it. And that too in 2019, 2020, the order was passed. Today is 2024. The answer is not satisfactory as to the delay, Lordship, and not appearing before the tribunal, though the address has not changed of the proceeding.
And proceeded name also shown Hajimuddin, my lord, whereas he is, my
That
lord,
all this,
Shaijuddin Mia.
all
But
this thing
different,
could have been
different,
taken up before. If the name has changed, then why is he before the court today, Lordship? The notice is same, it is of the same year, same time of when the reference was taken up.
What is your name?
my lord, Shaijuddin Mia, my lord,
And the notice was issued in the name of?
Haji Muddin.
Hajimuddin. Paragraph 3.
Lordship, can Lordship look at the inquiry?
Yes, my lord. After receiving the certified copy, this contention has been made. So far, verification report is concerned. Verification. So far, verification report, this is also certified copy. Annexure 1, Lordship, page 15, the verification report also is a certified copy, my lord. And after receiving this certified copy, we came to know. Hmm. 19/9, my lord, 2020. And Lordship came to know on 22/5/2024 after receiving enter record. Shifted from my Lordship Malibari Pathar under Moza Sondul in the district of Kamrup. Lordship, I have narrated, my lord. Twenty-fifth, 25th October.
Case number such and such. To the awareness trial. One reported. Along with the copy. Registry shall also forward a copy of each order. The deputy commissioner for data. As well as superintendent of police. The packet for data.
Highly obliged. And item number 5 also, my lord, similar situated case, my lord. Same report, my lord. Only name is found similar, same, Miasan Ali. And here also, my lord, same situated Kukarpar and Khongra, these two villages, adjoining villages. And Kukarpar notice was served, and he is resident of Khongra.
Where is the order?
Lordship. And same condition made, madam. I have page impugn, my lord, order, that is the same date on 19/9/2020, page 22. Similar language, similar order, my lord. Only name is different.
Yes. Respondent, anything?
Lordship,
to supplement?
the impinora also same date, verification also same date, only name different. And contention to two adjoining villas. Now he is also ready to contest the case, madam. Opportunity to be given. Otherwise, 66 voter list is there, his father's name. It is page, my lord, 23. In the
Chief, if he's relying on the 66 voters list, then he'll have a lot of explaining to do. 66 voters list shows the village to be Radha Kuchi, the grandfather's age at
Why should you look at those things that he is saying? Let him say activities that.
Yes, yes, Lord.
It
Let-
is his statement here, we're not.
let me face the track. I'll face the consequence. I'm ready to call.
That's why you indicate that if it doesn't appear before the third. Yes,
Lordship.
but see, the proceeding Buddha matters have clearly stated that Godfather and Khamra are adjacent.
And Lordship, it is not that they are not aware of the proceedings. They are very much in knowledge that they have proceedings against them, Lordship.
No, no, no.
Because the police inquiry, it is they who have given the information.
No.
So they know that there is a reference pending against them.
Just on 22nd of May, I come to know, after receiving the.
Lordship, I would like to place some point of time more judgments on this. When a police inquiry or a ERO report is present, they cannot take this plea that they're ignorant, they do not know that they have a reference pending against them.
No, police, this is a ARO report. It is one-sided. Whether my signature is there or not, no. Whether it was served to upon me, no. It is one-sided PPR. ERO prepared this
This is
verification.
not a police case, again, ERO and LP. So that report is active.
We want to go through the records.
If Lordship has made up mind to remand back, Lordship.
We made up our mind because of the record.
No,
If you want to,
Lordship has examined it, I will
no,
not.
no, if you
like it.
want to make an attempt to have our minds changed, then you need to look into
No,
the.
Lordship will remand it back. I'm sure we will again face them someday.
Heard, disposed. We'll pass out it.
High low blood. Same date, my lord.
Same day.
Same date. High low blood.
What's your good name?
Yeah, Ali Lordship.
Full name?
Asghar Ali Lordship.
What is the illegality in this order?
Lordship, I have submitted sufficient document, Lordship.
Sufficient document is necessary or something else to be proved? How you have proved your linkage?
Lordship, my elder brother and elder sister deposed, Lordship.
Elder brother, elder sister, what? They reduce evidence.
Yes, Lordship.
That is sufficient.
And my brother has a voter with my father.
What is your linkage? Which document?
Have a look at page, Lordship. 25, Lordship, page.
25.
Yes, Lordship. Sonaruddin is my brother, Lordship. He deposed.
Please come to page number 21.
Yes, Lordship.
You're projecting this Jabbar Sheikh as your father
Yes, Lordship.
and Swagi Nisa as your mother.
Yes, Lordship.
Now, Jabbar Sheikh is son of whom?
Jabbar Sheikh is son of Alimuddin, Lord.
Alim. Okay. In 1966 voter list, on Alimuddin, son of Nazir, been shown. How old was he?
Lordship, as this is there, that is admitted fact.
Father is 45.
Yes, Lordship.
Jabbar Sheikh is 40 years. His mother, Malansa Nisa, is 42 years.
But we if Honorable
Now-
Court considers the
1970, again,
yes, Lordship.
his father was 49 years. He himself was 44 years. Mother was 46 years.
Yes, Lord.
After 77, after 70, the next voter list is of
2010 Lordship, the proceed itself voter Lordship. Full Khatun and Father Jabbar.
where is the written statement?
Page 14 Lordship. 1-4.
On 14, page
Yes.
14.
Yes, Lordship.
So, in 66 and 70, it's fine. In 77,
Hmm.
instead of Jabbar Sheikh, one Jabbar Khani came up.
Yes, Lordship. Name discrepancy also there, and that has been explained in the WS Lordship. WSPS 18 Lordship, para 25.
What happened to Alimuddin and Malonsa Nisa?
They were grandfather, they expired Lordship.
In which year?
That has not been mentioned, Lord.
So they found missing in the voter list of 1977.
77.
You have not stated anywhere in your written statement what happened with your grandparents. Well, please come to page number 41.
Lordship.
He is your projected elder brother, right?
Yes, Lordship. Sonauddin.
Now, in the first line, he has stated that he is about 56 years old, right?
Yes, Lordship.
He is son of Jabbar Ali.
Jabbar Ali.
And at para 2, he has stated that he was born in the year 1967. Para 2,
Yes, Lordship.
right?
Yes.
Good. Now, please come to page number back to 25. Name of Sunaruddin exists
22.
along with one Jabbar Khani, whom again you are projecting as your grandfather, your father. Now, this Sunaruddin in the year 1977,
Mm.
how old was he? How old was he? 77 minus 22.
Mm.
How old was
55.
he? 50. So his birth year was 1955. But swearing an affidavit, your projected brother is saying that he was born in 1967. And he is son of Jabbar Ali.
Yes, Lordship.
He did not say that he is son of Jabbar Sheikh,
Lordship. He
nor
said,
Jabbar Khani. He is saying that he is son of Jabbar Ali.
but they stated in the WS Lordship same person.
WL. Question of the person he himself projected brother is saying that he is son of Jabbar Ali, born in the year 1967. And you are annexing a total list of 1977, one Jabbar Khani along with one Sunaruddin was 22 years in 1977. And that is only your link document is that Sunaruddin is your brother. Anything else?
No, Lordship.
You
Lordship.
prove directly or something which
His, one of his sister also deposed. Lordship, some discrepancy here in there, Lordship. At this stage, I am only going for interim.
please come to page number 47.
Lordship.
Here the Sunaruddin, your elder brother, projected elder brother said that your father or husband, nobody said when did the parents of the petitioner expired, nor the grandparents. Because after
Lordship.
70, there is no voter list of name of
Lordship. Have a look at page 53, Lordship.
83,
53, Lordship.
53.
Yeah.
Yeah.
Here is a statement, Lordship.
Hmm.
My mother expired 30 years ago and
Hmm.
father expired 40 years ago.
Who is this Rubhan?
Rubanu is one of sister, Lordship, proceeded sister, elder sister.
If it is 30 years in 2023, August 23, sometimes in the year 1993, have you proved any such voter list of your mother up to 1993?
Lordship,
Yes. Yes, Mr. Kaur.
My lord, item number 36 and 37. This morning, my lord, we are the appellants, my lord. A mention was made that your lordships cannot take up the matter. Lord, we have checked up, it's a fact, lordships appeared, my lord. Appeared as a standing counsel for department. We could lay our hands to the copy of the order also. Well, there is some end of the day at 4:30 that will happen. So I thought to make it may be listed tomorrow or day after tomorrow, my lord. Any other, there is one
Just,
more bench is there.
So what we'll do, we'll not fix the date.
Yes,
We'll ask the date to the
yes.
not report any other events without me.
There is urgency is there little some. Well, what the point?
Okay.
Tomorrow, day after. Deeply after.
Yes, Mr. Sharma, we'll call for the records at
Yeah.
the stage. Heard. Let it come to the parties. The by order dated.
Right.
30/11/2023, passed in FT 554 of 2019 by the learned member Foreigners Tribunal number 7, Borpeta, in a proceeding under Foreigners Act 1946, the petitioner was declared to be a foreigner who had illegally entered into the territory of Assam post 25/3/1971. Being agreed, the present writ petition has been filed, praying for setting aside and interfering with the opinion dated so-and-so, passed by so-and-so tribunal on the ground that the evidences led before the tribunal was not considered appropriately, and consequently the impugned order was passed. Before the court proceeds to hear the matter, let the records of case number so-and-so from FT so-and-so be requisitioned by the registry and the matter be listed after 6 weeks. When was it passed order? 23. The petitioner will appear before SP border Borpeta within 10 days from today. And if a bail bond of rupees 10,000 is furnished, then the petitioner, 10,000 with 2 local securities is furnished, then the petitioner shall not be detained without leave of the court. Stop. The petitioner will also not be deported out of the country during the pendency of the matter. Stop. When the petitioner appears before the SP order, the biometrics of the petitioner be recorded along with the address and contact number. List accordingly.
May please, your lord. I has been filed correction of the order, madam. Only included the case number, madam.
Mr. Hassan,
Yes, my lord.
better to have it next.
Yes, sir.
First of
First of October. Published.
we have to come with list on first name.
May I please, your lordship? My lord, in earlier order, my lord, the direction was given to my lord Superintendent of Police Bozali. But it would be my lord Borpeta, my lord. My lord, order is at page 9.
Same order. First of October.
First of October.
We'll have it on
Obliged.
first.
Obliged.
Wait, please. Worship, the impugned order is at page number 65, my lord. Contested case, my lord. My lord, that 65, my lord. 65, page number 65.
Against the order passed in November 2017, you have filed this writ petition now,
Yes, my lord. My lordship, he is a very poor person, my lord.
July 2024, almost after 7 years.
My lord, I have to, my lord, explain, my lord. In paragraph number 24, my lord, I have to explain, my lord. He has collected some money from the neighbors, my lord. Thereafter, he has to disclose, my lord. His father's name is, my lord, in the copy of NRC, thereafter, his voter list 67. And his name has been recorded in the voter list of 19.
Mr. Sharma, you have seen at paragraph 23 of the writ petition.
It is stated that petitioner has not been taken into custody till date, but
That is for you to understand. In a proceeding under the Foreigners Act 1946. Hardly it's a mark. As the best people by in a proceeding under the Foreigners Act 1946. That is Foreigners Act. Case number 50 within bracket 3 dash 4 bracket 155 reference ERO case number 12 87 by 30 by the impugn order dated 30/11/2017 declared the petitioner to be a foreigner who entered Assam after 25/03/1971, answering the reference forwarded by the Superintendent of Police Border Golfan. Agreed by the said order dated 30/11/2017, Foreigners Act Report Golfara. Petitioner has filed this petition on 09/07/2024, almost after 7 years. Therefore, proceeding proposed there will be reports of the 11 application number FP. Foreigners Act Report Golfara. It's a call for reports of the list of let this matter proportionally be developed.
May I pay for interim protection, my lord? Kindly, my lord.
For some time, already there.
My lord, one observation may kindly be given that after receiving LCR, my lord, interim may be considered, my lord.
Let
This
us
is-
consider the entry period of the petitioner shall be
Yes. May I please, your lordship? Lordship, contested matter, lordship. He had grandfather voter in 1966 and 70 and father 1985. Father has deposed, lordship.
Learned counsel to the party. By opinion dated 28/12/2023 passed in FT 1264 of 2017 by the Learned Foreigners Tribunal number 6, Kolkata. The reference by the state made under the provisions of the Foreigners Act 1946, was answered in favor of the state and against the petitioner, holding the petitioner to be an illegal migrant who had entered the territory of Assam post 25/03/1971. Stop. Agreed, the petitioner is before this court, praying for appropriate direction or order. Para. Let notice issue, returnable 6 weeks. Since the respondents are represented by the councils, notices are waived. However, extra copies be furnished within a period of 1 week from today. Steps on respondent 6 by registered post 80 within 1 week from today. Let the records of FT case number so and so from Foreigners Tribunal number so and so be requisitioned by the registry and the matter be listed thereafter. So in the meantime, petitioner, if the petitioner appears before the SP Borpeta within 10 days from today and furnishes a bail bond of rupees 10,000 and 2 local securities, the petitioner will be permitted to remain on bail and shall not be deported out of the country without leave of the court. Stop. When the petitioner appears before the SP Borpeta, the biometrics of the petitioner, biometrics of the iris of both the eyes and fingerprint, along with contact number and address detail, should also be recorded by the SP. List accordingly.
Obliged.
May it please your lordship. Lordship, item 9, 10, 11, all are family members. Lordship, may kindly take up item 10 first. In this case, lordship, petitioner's father was a declared foreigner, lordship. That order I have enclosed with this WTC 4692, lordship. Page 32, annexure 9 is the order, lord. Sorry, lordship.
Yes.
So, relevant portion, page annexure 8, page 33, lordship. His father's name is Mohammad Abdul Kalam. Second paragraph, lordship. Accordingly, this reference is disposed of against Mohammad Abul Kalam, son of Mohammad Hafez Ali, care of Musammad Shorumaina Begum, village Udoynagar, ward number 5, PS Gulaghat, district Gulaghat. Permanent address, village Singimari, Mauja, Laukhua, PS Rupohihat, district Nagaon. Assam is declared foreigners of between 1st day of January 1966, but before the 25th day of March 1971 stream. So he is directed to register himself by moving application of subsection 3 of section 6A of the Citizenship Act before registering authority of district in which he ordinarily resides within 30 days from the date of detection or identification as foreigner. So accordingly, lordship, there is a delay in approaching the registering authority. So his application was not accepted. Thereafter, we filed an writ petition before this court, that is annexure 9, page 34. While issuing notice, a direction was passed in this writ petition, that is page 35, last paragraph. we noticed that under Rule 19(1) of the Citizenship Rules 2009, application for registration has to be entertained within a period of 30 days from the date of receipt of the order of the tribunal declaring the person to be a foreigner of that particular stream. As per the proviso, registering authority is empowered to extend the limitation period for reasons to be recorded in writing to such period, but not exceeding 60 days. As per Rule 19(2)(a), under the circumstances enumerated therein, the period of registration can be extended to such period not exceeding 180 days. In that view of the matter, we are of the view that registering authority of Nagaon was not justified in not accepting the prayer of the petitioner for registration. We accordingly direct the registering authority Nagaon to register the petitioner as a foreigner belonging to 1966-1971 stream. To enable such registration, petitioner shall appear before the registering authority within 15 days from today. So accordingly, he appeared, Lordship, before the registering authority, and his registration certificate is Annexure 10, page 37. On the below part, Lordship, registered at Nagaon on 21/9/2016. Thereafter, that writ petition was disposed of. Page 40, Lordship, 22/5/2018. As registration was already done, Lordship, so writ petition was disposed of accordingly. After that, Lordship, the petitioner and his father, Lordship, again received notice. So we came before this Honorable High Court with a writ petition, Lordship, challenging both the notices, Lordship. Notice I have enclosed as Annexure 12, page 42, Mohammad Abul Kalam. And notice in respect to the petitioner, page 44, Annexure 13. Mohammad Anwar Hussain. And against his name, Lordship, his father name was there, son of Abul Kalam. Challenging these two notices, we have preferred WPC 5377/2019. And in this case, while lower court records were called for, after going through the lower court records, it came to notice that in the year 2020, the petitioner was already declared foreigner ex parte, Lordship. So I have obtained the certified copy from this High Court, Lordship, of that order. That is Annexure 15, page 51. The relevant portion is, Lordship, page 55. Order dated 27/4/2020. While we obtained the certified copy, then from the certified copy, we came to know that there are some persons who were declared ex parte as foreigner, including my wife and my mother also. So these three writ petitions we have filed. In fact, the petitioner received notice that was under challenge before this Honorable High Court, but his mother and wife did never received any notice from the tribunal. Now, ex parte order says already notice served. Even then, the petitioner did not appear, so Lordship ex parte decision. But I was under impression that my case is under consideration before this Honorable High Court. So, Lordship, I have not contested that case, Lordship. So, my humble prayer before your Lordship to give a chance to the petitioner to contest the case by filing written statement and all the evidences.
No, why were you under this impression that it is pending? For what
Lordship,
purpose?
after filing of the writ petition before this court, Lordship, this court has not granted any stay order, Lordship. So it was not within the knowledge of the petitioner. He was under impression that case is going on before the Honorable High Court, Lordship.
He is now under detention.
There is some negligence on our part also. We have not informed the client that there is no stay, Lordship. That I agree, but
He has been detained.
no, Lordship.
Then?
He is outside. from the while the hearing of the case was going on, Lordship, then only it was informed by court that from the LCR it reflected that he was already declared foreigner in the year 2020, Lordship. Thereafter, this order was passed by this Honorable High Court. Page 48, Lordship. The earlier writ petition was disposed of on that
No,
day.
this was filed by Abul Hussain,
Yes, Lordship. Abul
Abul
Hussain,
Kalam.
Abul Kalam and Anwar
Anwar.
Hussain. Yes, Lordship. Abul Kalam, Lordship, we are still searching. And moreover, Lordship, after filing of these three writ petitions, another notice was served to the house of the Anwar Hussain and his mother, Lordship. Again, they have served two notices, Lordship. In the name of Abul Kalam and Anwar, petitioner's father and petitioner's mother, Lordship. I have seen these numbers, Lordship, FPG 1580 in the name of Abul Kalam of 2011 and 1579-11 in the name of Ambia Khatun, my mother's name, Lordship. So while I have challenged these ex parte orders, another notice already issued, Lordship. So again and again they are issuing notice. In fact, Lordship, we are residing in Gulaghat for our livelihood, Lordship. We are laborers. So when we return to our village, Lordship, just 1 week ago, Lordship, we have received these two notice again, Lord.
Where is the order 27-4?
Page 51 and 58, Lordship. No, Lordship. 27, that is ex parte order, Lordship. Page 51 to 58.
We have said that it's already declared. Besides this writ petition, there are other writ petitions you are challenging the same order.
No, Lordship.
Then?
Other writ petition, I have challenged the earlier notice, Lordship. This proceeding, Lordship. This proceeding I have challenged in earlier writ petition.
Which was disposed of by the
Lordship.
page 47 order.
Yes, Lordship. After going through the LCR, when we came to notice that in the year 2020, already he was declared foreigner, Lordship. And in that common order, Lordship, petitioner's father name was not there. By common order, already 5 persons were declared foreigner, including these 3 petitioners from the same family, Lordship. Other 2 petitioners, we are not, Lordship, they are not known to us.
You go and appear before the tribunal and contest the matter.
Lordship, for that, your Lordship has to allow me and give a chance to contest the case.
Yes, Mr. Sharma, what do you say?
Lordship, let him allow to go and contest the case, Lordship, regarding 1781, Lordship. In just
What is
case
your prayer
number-
in the other petition?
That was withdrawn, Lordship.
No, these other item numbers,
Lordship, similar prayer, Lordship.
similar
As
challenging what?
In those cases, we have not received notice, Lordship. Here we have not received notice, and after that we filed WPC before this court. And that is reflected in the order itself, Lordship. Page 48, insofar as the petitioner number 2, namely Anwar Hussain, is concerned, from the trial court record of the Foreigners Tribunal, Jorhat, it is seen that as against the petitioner number 2, a reference being case number FTG 1781.
We call for the record.
Yes, Lord.
Record is already here, Lordship, in earlier,
Which matter?
in that case, Lordship, that is WPC 5377.
But whether
Page number 48.
Yeah, it is disposed of on 23/7/2024. And thereafter, we have obtained certified copy from this High Court only, Lordship.
whether the records of FTT 1781/2011 is available here in that record.
Lordship, along this writ petition, it was available, and thereafter we have obtained this certified copy from this High Court, Lordship, page 51. This is our High Court certified copy of the common opinion given by the tribunal, Lordship. There, notice both are on record, yes, Lordship, in the earlier writ petition, there is a direction to return the.
We'll just request him to inquire from the section if it is there.
Lordship, whether it is,
We-
I have obtained the certified copy on 3/8. Till 3/8, it was
Ah.
here, Lordship.
More than a month.
Yes, Lordship. So
We
maybe
wait
in-
for some time.
Lordship, oblige.
That is your option.
May please, your lordship. Lordship is a contextual matter, lordship. Linkage can be found Annexure 11, total list of 1997, page number 54 to 55. Petitioner with her brother. And also voter list of 2005, voter list of 2018, one ration card. These 3 documents are linkage proof, lordship. Father of the petitioner, lordship, has 2 siblings. Petitioner's mother and secretary of Sri Sri Sujagiri SS Limited deposed before the tribunal as DW2 and 3. Petitioner herself DW1. Okay. 1/7/24, 11/7/24. The names of the petitioner's parents appeared in the voter list of 1966 and 1970, 1975 till 1975, father, mother both. Only some name discrepancy, Lordship. Petitioner's father's name Rakhal Chandra Pal, somewhere Rakhal Pal Chandra is deleted from his name, Lordship. Also, in the name of mother, same thing happened. Her name also. She married with a person. First time her name appeared with her husband, Lordship, in the Bhutan in 1985. After her husband's demise, she came back to her paternal home. After that period, her name appeared with her paternal members of the paternal family. Ninety-seven, 2005, 2018, 2018, I don't know.
In the ration card,
Not
the witness has stated something contrary, stated,
ration card.
uh,
In which page number, Lordship?
you come to page number 31, I think,
31.
31.
Yes.
Or you can start from page 30, cross.
The register book which I have carried, number of members stated as 2, but number 2 members' name is not mentioned. There is no photo of the members in our register book. There is round seal of our office has put on the photo, but there is no such round seal on the photo. The second member in exhibit F. In my register book, Abharani Pal, wife of Rakhal Pal, exists, but Abharani Pal, wife of Rakhal Chandra Pal, is stated in the ration. That is why, Lordship. Rakhal Chandra Pal,
No,
Rakhal Pal.
Read on, read on.
There is no such countersign in the ration card, though the photocopy I have carried with the notice, it is seen there is a countersign. Exhibit F and the photocopy of the ration card, which was given to me with the notice, are not same. My countersign is not in the exhibit F, but the photocopies of the documents which were served to me with the notice, my countersign is there. The handwritings in exhibit F and the photocopy of the ration card carried with the notice are different in the putting of the name of second member as well as the father's name. Father's name, Lordship, this said to the father's name only, Lordship. In exhibit F, ink is scattered in the name of the second member, whereas this has not happened.
He has categorically stated that exhibit F is not his signature.
Yeah.
And the photocopy which he has carried, which is a photocopy of the record, and the one that is produced are different.
But the ration card is in the name of Rakhal Chandra Pal, Lordship.
Therefore, the doubt.
It is issued in the name of Abharani Pal, wife of Rakhal Pal. So it is clear, Lordship. It is Abharani Pal is mother of the petitioner. And Rakhal Pal, alias Rakhal Chandra Pal, is father of the petitioner.
No, but the document which you produced in evidence, it was not true. That ration card.
The round seal thing is not proved, Lordship. Otherwise, he said that he issued the ration card in the name of Abharani Pal.
No, you read that cross-examination, he's completely disowned it.
Yes, say the members of the number of members, Lordship. Then there is no photo of the members in our register book. Photo is not in his register book. There is wrong. This is said about the seal of their office on the photo, but he didn't deny that the ration card is issued to them, issued in the name of Abharani Pal. Only the seal thing and number of members. As she has returned back from her husband's home because he was the husband of the petitioner died, Lordship, might be this can be the reason, Lordship.
Yes, Mr. Sharma.
Yes, Lordship, proceed is Binapani Pal, Lordship. And he has to establish her link with Rakhal Chandra Pal, Lordship, which existed prior to 1966, Lordship. But there is no such document, Lordship, by which her link can be established, Lordship.
Also, Lordship, one annual Kharaji Patta, Annexure 15, in her father's name, which is Rakhal Chandra Pal. Page number 64 to 65. Rakhal Chandra Pal, the Baba hoy.
এই বিনাপানী লিংকটো কেনেকে হেৰি কৰিব
Link to আপোনাৰ এইটো 97 ত আহিছে।
We don't
Ring
find-
number रहा नहीं ना?
We don't find any infirmity in the order.
Yes.
Lordship, may I see the voter list of 2005?
So at this stage, we'll only call for the records.
She's the oldest lady, Lordship. 64 years might be. So,
We'll
Lordship, may I show
consider
some
your
kindness to
prayer
the
after
petitioner.
the records are received. We'll consider. When was the opinion passed?
2022 Lord.
Huh?
22.
22, for 2 years, nothing has happened.
There is some delay also, Lordship.
There's some delay.
As she is the old as a lady and presently
We'll
resided.
consider your interim after
your
the
brother,
records are there. Heard MS.T. Begum, Learned Counsel for the petitioner, Mr. G. Sharma for the Department of Home. Respondent number 2, 4, 2 and 4.
2 and 4.
None appears. Anyone for union? None appears for the union. MS.P. Barua for respondent number 5. And Mr. G. Hazariga for respondent number 3. None also appears for respondent number 6 at this stage. This court would like to call for the records pertaining to opinion dated records of FT case number G4 within bracket capital M/219/18 from the Foreigners Tribunal 4th Walpara. Stop. The opinion dated 30/04/2022 passed in so and so case by the learned member 4th Walpara had answered the reference made by the state in affirmative and against the petitioner, holding the petitioner to be a foreign national who entered into India illegally on or after 25th March 1971. Being aggrieved, the present writ petition has been filed. Let the matter be listed after 4 weeks
Seeing the old as a lady, Lordship, may consider.
on receipt of the tribunal records. Prayer for interim will be considered upon perusal of the records on the next date.
Good.
What are you saying? Okay. What is it? The records have been sent back.
Lordship.
We'll have to call it.
It is admitted that we have received notice in this case, Lordship.
Sorry?
In this case, we have received notice, Lordship. Item number 10, Lordship. 9 and 11 only we have not received notice, Lordship. Only after taking certified copy, we came to know that.
No, but proceedings are the same in 9 and 11.
No.
No, Lordship.
Separate proceeding.
Separate proceeding by common order, 5 persons were declared foreigner, Lordship. Kindly see page 53, Your Lordship. Only the records of FTG 1781 was called for in the earlier writ petition. So in that records, we came after obtaining certified copy for this petitioner, Anwar Hussain. We came to know from page 53 that 5 persons were declared foreigner, Lordship. Then on inquiry, we came to know that serial number 2 is the writ petitioner, Lordship, Anwar Hussain. Serial number 3, Lordship, will find Mosammad Ambia Begum, mother of the writ petitioner, Lordship. And serial number, Lordship, 4, Fatema
All right,
Khatun.
we are calling for the records. Heard MSR Chaudhary, learned counsel for the petitioner, Mr. G. Sharma appears for respondent number Respondent 2 and 4. Mr. MSP Barua for respondent 5, Mr. G. Hazariga for respondent number 3. The petitioner before this court had earlier petitioner before this court had earlier approached this court with another by filing WPC 5377 of 2019. Stop. By the said writ petition, what was challenged in the earlier writ petition?
The notice served to the petitioner lordship and his father. It was the case of the petitioner in that writ petition that his father was a declared foreigner and he subsequently was registered lordship. So the second notice to his father and
No, notice served in which matter? 1781.
yes, lordship, that is the notice we have challenged in earlier writ petition also. As my father is a registered citizen lordship, so my case may be considered.
Had challenged the notice dated
Notice dated lordship, that is notice dated 1/3/19 lordship.
page number.
Page number 44 type copy and the original is at page 45.
Had challenged the issuance of notice dated 1/3/2019 by the Foreigners Tribunal Jorhat in connection with Foreigners Tribunal case number FTG/1781 of 2011. Stop. The case projected before this court in the earlier round of litigation, by the petitioner is that since his father was already declared to be a foreigner in the stream of 1/1/1966 to
25/3.
24
Then 25 day of March
1971.
1971.
And a direction was issued by the tribunal earlier to register before the FRRO, concerned FRRO. And your father registered already?
Yes, Lord.
And
I
pursuant
have
to
an
this,
extra.
the father of the petitioner, namely one Abul Kalam, had already registered himself.
On 21/9/2016.
Registered himself on 21/9/2016.
16.
The petitioner is agreed that the notice by the Foreigners Tribunal Jorhat was issued in connection with FTG 1781 of 2011 on the petitioner to answer the reference as to why the petitioner should not be declared to be a foreigner or post 25/3/1971.
Right.
So, the coordinate bench by order dated 23/07/2024 upon perusal of the records of the tribunal records pertaining to FTG 1781 of 2011 called for from the Foreigners Tribunal Jorhat. Observe that the records reveal that by a common order dated 27/04/2020 passed in FTG/1781/2011 and other connected references, the Foreigners Tribunal Jorhat had already rendered its opinion declaring the petitioner number 2, namely uh, Anwar Hussain, is it?
Yes, Lordship. Anwar
Anwar
Hussain.
Hussain, Anwar Hussain, within bracket, namely the petitioner herein, to be a foreigner who has illegally entered into the territory of India, Assam, after 25/03/1971 without any valid documents. Stop. Upon such facts being revealed from the tribunal records, on the prayer of the petitioner, the matter writ petition was permitted to be withdrawn in respect of the said petitioner number 2, namely Anwar Hussain, MD Anwar Hussain. Stop. Para. In view of the finding of the coordinate bench by the order dated 23/7/2024, passed in WPC 5377 of 2019, the present writ petition has been filed, putting to challenge the opinion dated 27/04/2020, passed in FTG /1781/2011 by the Foreigners Tribunal, Jorat. Stop. There are learned counsel for the petitioner submits that the petitioner was not served with the notice, and consequently, it is only during the pendency of the earlier writ petition that the petitioner was informed that the petitioner came to be aware of the impugned order whereby the Foreigners Tribunal Jorhat had declared the petitioner to be a foreigner / illegal migrant who had entered illegally into the territory of India post 25/03/1971. Learned counsel for the petitioner submits that perusal of the impugned order dated 27/04/2020 reveals that the petitioners could not be traced out, and consequently the process servers stated to have completed their service by affixing the notice on the outer part of a house where the petitioner were stated to be residing earlier on rental basis. Stop. It is submitted that such conclusions arrived at by the tribunal was not based on any material. Stop. It is submitted that the petitioners have been residing in the same address, and there was no question of the petitioners not being available at the address reflected in the notice, as the said notice was sought to be challenged by the petitioner in WPC 5377 of 2019. Stop. It is therefore submitted that the ex parte order be interfered with, set aside, and the matter be remanded, permitting the petitioner to contest the reference raised by the state against the petitioner. Para. Learned counsel for the respondents submits that the records would be necessary to the records may be called for at this stage. Stop. Para, considering the rival submissions of the councils, and also in view of the finding of the tribunal in the order dated 27/07/2020, that the notices were considered to have been served as per the provisions of clause 3 within bracket 5, bracket close, bracket small f of Foreigners Tribunal Order 1964, and that the notices were affixed on the outer part of the house, which was stated to have been used by the petitioner on rental basis. As during the process of service of the notice, the petitioners could not be traced out. Accordingly, let the tribunal records connected to case number FTG 1781 of 2011 to be requisitioned by the registry from Foreigners Tribunal, Jorat. Interim prayers of the petitioner will be considered upon perusal of the tribunal reports.
Lordship, in this case, my submission is that, Lordship, we have received notice. That notice was under challenge in WPC 5377. Your Lordship has recorded my submission that I have not.
If we record that submission, then we have to dismiss your petition.
No, Lordship,
Because if you have received notice,
Lordship, I have received notice.
when did you receive notice?
Before filing of 53277. We
Date.
have, Lordship, date, that was under challenge before this court, Lordship. And during hearing only, it came to notice that already an opinion was rendered.
See, the tribunal has recorded a finding that you could not be traced out, therefore it was affixed on the outer door.
No, Lordship, we are normally.
That's the tribunal's observation.
Yes, Lordship.
And you say that you have received the notice.
It is a fact, Lordship, as because we have already
So-
challenged that notice before this High Court,
So
Lordship.
therefore, we want to see from the record.
And one thing, Lordship, we are the resident of Nagaon district.
Where is that copy of the notice?
Notice I have enclosed. Page 42 is my father's notice and page 44 is my notice, Lordship. We both were given notice by the tribunal, Lordship. For that only, this court, while disposing this 5377, stated that petitioner number 2, namely Anwar Hussain, that Lordship, and accordingly she prays to permit the petitioners to withdraw the writ petition only on behalf of petitioner number 2, so as to enable the petitioner number 2, namely Anwar
We have
Hussain,
recorded that. We have recorded that.
Anwar Hussain, to challenge the award passed against
That's
him,
right, we have recorded that.
Lordship.
And therefore you have filed this petition challenging
Lordship,
this award.
So I have
But the
received notice,
No, but the question is, tribunal has returned a finding
Lordship,
on the basis of a report given by its process server.
Lordship.
Whereas you say that you have received a notice,
Yes, Lordship.
in which case you have to explain why you did not appear before the court,
Lordship.
but tribunal. When did you receive the notice? There is no averment here.
Lordship. As it was under challenge in the earlier writ petition, so Lordship.
No interim.
Lordship.
Proceedings were not stayed.
Yes, Lordship.
Then
So Lordship may kindly grant interim protection
No.
till the nine, 10 and 11, Lordship. 9 is my
Let
mother,
us complete with item, what is this item? 10.
10, Lordship.
10. Records be called for, so and so, to be listed after 4 weeks. And prayer for interim will be considered on perusal of the tribunal records. Yes, now in the other matters,
Lordship, 9 is 4690.
Wife of Anwar Hussain.
When we apply for the certified copy of the opinion of the tribunal for the writ petitioner number of item 10, Lordship. Then only we came to know that from a common order, Lordship, she was also declared foreigner, expertise, Lordship. But in this case, Lordship, this writ petitioner has not received any notice, Lordship.
Do you stay together or you stay separately?
We stay together in a
Together.
rented house, Lordship, and
Out of 4 persons, 1 person has received.
so that notice came to our own village in the district of Nagaon, Lordship. But this was maybe, Lordship, they posted it in the rented house and we left that house, Lordship, after our, that,
Here also we'll call for the records only. relevant
Lordship.
records.
Yes, Lord.
Hard
Yes,
to আগৰ order to cite. The petitioners have put to challenge the ex parte common order dated 27/04/2020 passed by the Learned Foreigners Tribunal Jorhat in FTP/1782 of 2011. So, at this stage, the court considers it appropriate to call for the tribunal reports before proceeding further in the matter. Let the reports be called for by requisition by the registry and the matter be listed after 4 weeks along with item number 10.
4692, Lordship, WPC 4692.
469. And then item number 11.
4693, Lordship, his wife.
Item number 11, same order, tribunal record. Order is the same. Date of the order is 27/4/2020. Passed in FTG 1783 of 2011. Report we call for from Jorhat. And please along with item number 10.
Lordship, interim order in. all
Interim
the-
orders to be, interim prayers to be considered after perusal of the report.
Lordship, I'm deeply obliged.
13.
Briefly, the Lordship. My lord, here in this case, my lord, parents are voter in 1966, 50, and onwards, my lord. And the mother was examined. I want to Lordship's attention, my lord, to the impugned judgment, my lord. It starts from page 72. My lord, kindly have a look at, my lord, a summary of the impugned judgment at page 79.
At page
79. 79. My lord, summary, particularly the paragraph 4 to 8, my lord. In 4, my lord, from exhibit 1 and 2, it has been ascertained that OP's parents came to Assam from the specified territory sometimes before the cutoff date 1166 and resided in the state up to 70. Then, my lord, paragraph 5, from exhibit 3 and 4, it has been ascertained that OP's parents had resided in Assam for another state from 85 to 97. From
No,
exhibit-
you are referring to 5.
My lord, I'm,
Right.
my lord, 4, 5, and up to, my lord, 7. My lord. My lord, in para 5, my lord, exhibit 3 and 4, it has been ascertained that OP's parent had decided in Assam for another state, 85 to 97. Then, my lord, 6, exhibit 5 and 6, it has been ascertained that OP's mother and some other family members had decided in Assam from 2010 to 2017. 7, appreciating the exhibits 1, 2, 3, 4, 5, and 6 conjointly, it has been ascertained that OP's parents did not reside in Assam for about 15 years during the period of 1970 to 85, and therefore they are not eligible to be regularized as a deemed citizen of India. My lord, can it be, my lord?
Regularized.
My lord, voter list are there continuous, my lord. Some voter list not been placed, and therefore they have, tribunal has taken that view, my lord. Can it be, my lord, possible, my lord? 70, 66, 70, 85, then, my lord, 97 voter list are there, 2010 voter list, then 17 voter list, 2022 voter list. can the tribunal can say so, my lord. Some period he's not there, so he's somewhere else, he's resided somewhere else, so cannot be regularized as citizen. Tribunal is not entrusted to decide that here, my lord. Mother was examined, my lord. Mother is 66 onwards, voters, my lord.
Yes.
My lord.
So what is wrong here with the observation?
My lord, what is correct here, my lord?
Section
My lord,
16.
the tribunal held that in this period, somewhere else, my lord. Is there any materials to say that I reside somewhere other
No,
place, my lord?
but is there any material to show that after 66 you have been residing here? What materials have you placed?
Yes, voter list is 85 voter list I have produced.
No, between that.
My lord, is it a my lord, requirement, my lord, to produce voter list of every year?
No.
And tribunal
subject-
held that he
but-
resides somewhere else.
But subject to correction, please read section 6A, subsection 2 for our benefit. Citizenship Act.
My lord,
Do you have a copy?
no, I have no copy.
We'll give you a copy. I won't read it.
Subsection
Subsection 2.
of section 6.
6A.
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 Subject to the provisions of subsection 6 and 7, all persons of Indian origin who came before the 1st day of January 1966 to Assam from specified territory, including such of those whose names are included in the electoral rules used for the purpose of general election to the House of People held in 1967, who have been ordinarily resident in Assam since the dates of their entry into Assam, shall be deemed to be citizen of India as from
So-
the first day of January.
So this is the
1960.
mandate
Is
of the
there-
section.
Yes, my lord, here, where is the mention that every day, year, he is to put his voter list?
You read the last line again. Who have been ordinarily resident
Yes,
since their date of entry
my lord,
into Assam from 1/6/1166.
my lord. The voter list of 85 is there,
Therefore,
voter list of 97 is there.
no, that is the finding of the tribunal.
No. Tribunal said that he resided
From
elsewhere.
70 to 85, there is no voter. No mention. Before 70 years, after 85 years.
My lord. The continuous, the voter list, my lord, 85, 97,
Which
then
is
my lord,
why-
2010, this
See,
goes to show
which
that
is why
they are residing
No,
continuously. my lord.
Mr. Sikdar, which is why for exercising your right of franchisee during times of election, wherever people are employed, they come back to their place where their
My-
names are registered.
Very unfortunate, my lord. My lord, my lord, every year's voter list have to be produced, my lord,
Not necessary, but you must give some,
my lord.
to say that this finding of the tribunal is per se perverse.
My lord,
But this is the mandate of the section.
my lord, that has been, tribunal has to some extent exceeded the jurisdiction. my
How?
lord. No, my lord.
Tribunal
it's
has
not-
merely said, tribunal fell short by not pointing out 6A2. It only
My
said
lord,
70
my lord,
to
I am
85
to
you
show
have
my ordinary resident. When I am voter in 66, 70,
But then,
85,
but then you have to
97.
explain what happened to you from 70 to 85. Supposing today my name appears in the voter list, I am not available next year or the next election for some reason, my name will be there in the voter list.
My lord, in one judgment, my lord, in Hyder Ali case, my lord, this honorable court has held that uh, in that case, Hyder Ali case, the voter list of 70 to 97 was produced, and there was an adverse order. And this honorable court has held that it would have been a bolster if any voter list in between this period would have been
No,
there.
we are
But
not-
thereby,
We are not rejecting your prayer. We are only trying to find out an answer to your submission in regard to the summary from serial number 4, 5, 6, 7 or 8.
my lord,
You pointed out that the finding of the tribunal at para 7 does not carry any legal reasoning.
my lord,
It is
that
not.
is my submission. my
It
lord.
is not as happily worded as one would have wanted it to, but you have to satisfy the mandate of section 62.
My lord, uh,
So therefore, we'll call for the records at this stage.
my lord, I may
Yes.
be protected in any prayer, my lord. I have sufficiently proved the case. We have also annexed the, my lord, Jamandi copy where my father's, we got land from fathers, my lord. And father is also voter in 66, my lord. And there are some other documents also,
Heard-
Panchayat certificate,
We are calling for the record at this
my
stage.
lord.
Heard Mr. A.K. Sikdar, and counsel for the petitioner. G. Sharma for respondent 2 and respondent 4. MSP Barua for respondent 5. Mr. Hazarika for respondent number 3. The petitioner is aggrieved by the opinion dated 30/11/2023 passed in BPT/11th within bracket FT 1966/2017 by the Foreigners Tribunal Assam, Borpeta 11th. Answering the reference by, of the state in a proceeding under Foreigners Tribunal Act order, the Foreigners Tribunal, a Foreigners Act 1946, answering the reference in affirmative in favor of the state and against the petitioner, holding that the petitioner could not discharge the burden of proving that her parents resided in Assam as its ordinary residence continuously from the date of their first entry into it before 1/1/66, and that they are eligible to be regularized as deemed citizens of India under Section 6, capital A2, or that the petitioner was born in Assam or even came to the state before 1/1/66, and therefore she was a citizen of India either under Section 3 or Section 6, capital A, within bracket 2 of the Citizenship Act. Para being aggrieved, present writ petition has been filed by the petitioner challenging the impugned order passed by the tribunal. Stop, it is submitted that the findings arrived at by the tribunal are not based on the evidences produced, and the evidences were not considered adequately by the tribunal while rendering the impugned findings. Stop. Para, at this stage, this court would like to call for the tribunal records pertaining to case number so-and-so from Foreigners Tribunal Assam, Borpeta 11th. Stop. Let the registry requisition the records and place the matter before the court after 4 weeks. Any interim prayer, the petitioner will be considered upon perusal of the case
My lord.
reports.
My lord, that can be considered at this stage, my lord. My lord.
23.
Only interim may be considered at this stage.
All right. In the interim, the petitioner will appear before the SP border,
Borpeta.
within 10 days from today. And if the petitioner furnishes a bail bond of rupees 10,000 with 2 local securities of like amount, petitioner shall not be detained in the detention center or shall be deported out of the country without leave of the court. Stop. When the petitioner appears before the SP border, the biometrics of the iris of both the eyes and fingerprints along with contact number and address be recorded by the SP. The petitioner will also not move out of the territorial jurisdiction of the SP border without written permission.
Development.
List according.
My lord, one mistake is Munavadi mistake, my lord. In my lord, judgment dated 24, but we have mentioned wrong 23, my lord. We have wrongly typed as 24 in page
In the
23.
post title,
Yes, my lord. Not post title, but prayer portion, page 23.
prayer portion.
Yes, my lord. Page 23 and 24, my lord. We will be allowed to correct it, my lord. So we have wrongly typed it as a 24, but it would be 23, my lord. Page 23, my lord.
It is also submitted that due to inadvertent mistake in the prayer of the writ petitioner, the impugned order where is the opinion page number?
My opinion at space is 72, my lord. At 73, relevant question.
It is 3011.
3011.
It is.
We have typed
is-
it as a 3011
mentioned as
20.
3011 2024 instead of 3011 2023. Petitioner seeks liberty, this court, to make the necessary corrections. What about the course title?
My lord, cost title, my lord, it's okay, my lord.
Same
Cost
mistake.
title also in page 2, my lord, there is a mistake, similar mistake.
As well as in the course title. But then you'll have to file amended course title now.
My lord, will file. Or we file an amended page, my lord.
The petitioner is permitted to make corrections by hand in the prayer portion of the writ petition, correcting the order to be 30/11/2023 instead of 30/11/2024. Stop the corrections be made in the presence of the court master. Stop. Insofar as the course title is concerned, petitioner will file corrected course title before the registry of the court.
Mile.
Within 1 week from today.
Mile.
Not within 1 week, you file it within 2 working days. Because we have directed you to appear before the SC.
My lord, we will file, my lord.
By 2 working
By
days.
tomorrow, I will file, my lord.
2 working days.
My lord, in 14, my lord, grandparents are voter in 1966. At page 26, in 11 portion, at page 27. Grandfather Tosir Ali, grandmother Sokina Khatun. And well, in 70 voter list, father is voter along with the grandparents. And father was examined well. Here, my lord, tribunal also similar point is picked up. My lord, voter list of 77 he has mentioned in the WS, but not executed. So tribunal held that in between 1970 to 97 no voter list. Voter list they have, my lord, not executed by mistake, but mentioned in the WS. Lordship, the voter list of 75 is also, my lord, at page 30. Father and parents with grandparents voter.
What are your link documents?
My lord, father was examined. My lord.
Hmm?
Evidence of father was the, my lord, link document.
Where is the father?
My lord,
Deposition
at his cross-examination part at page 54.
54.
My lord. Vernacular person at page 56. Abdul Majid, aged about 72 years, son of late Qasir Ali. Moziran Nasa is my daughter. Moziran Nasa got married in Darugar Alga in the year 2005. Marriage venue 126 number 0. Marriage Kazi was from this aforesaid village. I cannot say when the Kabinama was extracted. It is not a fact that Moziran Nasa is not my daughter. It is not a fact that I have stated falsely performing marriage of Moziran Nasa from Uzirot solemnized by Kazi of the same village. I have no certificate with the relation of the Moziran Nasa as my daughter. I have two wives, namely Johiran Nasa and Jamila Khatun. I cannot say when Johiran Nasa was died. I cannot say when Johiran Nasa casted vote. Johiran Nasa has died about almost 30 years ago. It is not a fact that Johiran Nasa is not my wife. Present age of Moziran Nasa is 35 years. Johiran Nasa was alive at the time of birth of Moziran Nasa. I have three children, namely Moziran Nasa, Jamir Ali, and Mohida Khatun. Moziran Nasa is the daughter of Johiran Nasa. I cannot say about the marriage year of Jamila Khatun. I married Jamila Khatun after 3-4 months of the death of Jomiran Nasa. It is not a fact that Abdul Majid, myself, is not father of Moziran Nasa, and Abdul Majid is mentioned in the documents, is not me. My lord, in the proceeding, my lord, he has to examine the Kazi and the.
Kindly read the vernacular again.
My lord, vernacular.
Yeah.
Moziran Nasa মোৰ ছোৱালী হয়। Moziran Nasaৰ বিয়া 2005 চনত দাৰোগাৰ আলগাত হৈছিল। বিবাহৰ স্থান 126 নম্বৰ উজিৰৰ চৰ। বিয়াৰ কাজীজন উক্ত গাঁৱৰে আছিল। মই এই বিয়াৰ কাবিননামাখন কেতিয়া ওলোৱা হৈছে মই ক'ব নোৱাৰিম। এতিয়া এইটো সত্য নহয় যে Moziran Nasa মোৰ ছোৱালী নহয়। এইটো সত্য নহয় যে Moziran Nasaৰ বিয়া উজিৰৰ চৰৰ পৰা হোৱা আৰু একে গাঁৱৰ কাজীয়ে বিবাহ সম্পন্ন কৰোৱা কথাটো মই মিছা কথা কৈছো। Moziran Nasa মোৰ ছোৱালী হিচাপে সম্পৰ্কৰ কোনো ধৰণৰ প্ৰমাণ পত্ৰ নাই। মোৰ স্ত্ৰী দুজনী নাম ক্ৰমে জহিৰুন নেছা আৰু জামিলা খাতুন। জহিৰুন নেছাৰ কেতিয়া মৃত্যু হৈছে মই ক'ব নোৱাৰিম। জহিৰুন নেছাই কেতিয়া ভোট দিছিল মই ক'ব নোৱাৰিম। জহিৰুন নেছা এতিয়াৰ পৰা অনুমানিক 30 বছৰ আগে ঢুকাইছে। এইটো সত্য নহয় যে জহিৰুন নেছা মোৰ স্ত্ৰী নহয়। Moziran Nasaৰ বৰ্তমান বয়স 35 বছৰ। Moziran Nasaৰ জন্মৰ সময়ত জহিৰুন নেছা জীৱিত আছিল। মোৰ ল'ৰা ছোৱালী 3জন, যথা নামক্ৰমে Moziran Nasa, Jamshir Ali, আৰু Mohida Khatun। Moziran Nasa, Johiran Nasa ছোৱালী হয়। জামিলা খাতুনৰ বিয়াৰ জনটো মই ক'ব নোৱাৰো। জহিৰুন নেছাৰ মৃত্যুৰ 3-4 মাহ পিছত জামিলা খাতুনক মই বিয়া কৰাম। এইটো সত্য নহয় যে Moziran Nasaৰ পিতৃ আব্দুল মজিদ মই নহয় আৰু নথিপত্ৰত উল্লেখ থকা আব্দুল মজিদ মই নহয়।
What will be the evidentiary value of this father's deposition?
My lord, he has clearly.
How has he projected himself as a father?
Yes.
Other than the deposition?
He has clearly said that Moziran Nasa is his daughter.
Other than the deposition?
Other than the deposition, my lord, she has also produced one Gabra certificate that could not be proved because the tribunal did not allow. And there was a petition filed on behalf of the petitioner to prove that, and that petition was rejected. Lord, you may kindly have a look at the page 63 of the judgment, middle portion. On behalf of the petitioner, a petition was filed for further evidence. The purpose was to examine the Kazi and the Kabura, and that could not be done because the petition was rejected and the evidence was closed. My lord, at page 63, middle portion, after recording the evidence of the proceeding and DW2, the proceeding has taken various adjournment for further evidence in so and so. Proceeding has taken adjournment for further evidence in various date on so and so, so and so.
So
On
the
12,
only the deposition is the basis. Your link document, link, your projected link is only the deposition of the
My
father.
lord, at this stage, my lord, father, but there was an attempt to examine the Kazi and the Gabura, but that was not, the petition was not allowed.
Not allowed?
Rejected, my lord. My
By
lord,
which
kindly,
By which order?
my lord, kindly, that order has been not annexed, but it is mentioned in the judgment, my lord, page 63.
63.
63, my lord. My lord, in the middle portion, after recording the evidence of the proceeding and GW2, the proceeding has
taken so many adjournments.
Adjournment, that is there, my lord. But on 12/12/2023, this reference is fixed for further evidence. If any last opportunity was provided to the proceeding, but on that day, the proceeding again file a petition paying for another date for further evidence. After appraisal of entire case record and after hearing both the parties, it is in the view that as the last opportunity was provided to the proceeding for further evidence, seeking another date is nothing but a delay tactics. Hence, pair was rejected by order dated 12/12/2023.
That is
12/13 and the evidence.
rejected. Rightly rejected.
My lord.
You have been granted so many adjournments.
My lord, further evidence, my lord, the opportunity should be.
No. See, there are two things. Opportunity to go for further evidence is one thing for which you have been given not less than 10 opportunities, 10 different dates. If it is a case that in spite of summons being issued, the witness has declined to come or has not come, then your application before the tribunal would be to compel the witness to be present.
And fact is that no notice, someone was issued by the tribunal.
No notice because you prayed for adjournments on all these dates.
My lord, I not prayed for, but I prayed for further evidence.
No. See, since 21/12/22, proceeding has taken adjournments for further evidence on various dates.
Petition proceeding again file a petition praying for another date for further evidence.
That's
Yes, my
right.
lord.
So, in view of
Even if that, my lord, the father was
11
exempt.
dates, in view of 11 dates granted earlier, the application filed on the 12th date has been rejected. What is wrong about it?
My lord, even though my lord, father was examined, my lord.
That's what we are saying. Mr. Sikdar, you are an astute counsel. Father has been examined.
My lord.
Now there is nothing in the deposition to say that there are some collateral evidence to draw inference that yes, he was the father. Nothing.
My lord, I have exhibited the Kabinnama. My lord, that can be considered as a corroborative
But the
document.
Qazi was never examined.
My lord, that not examined. My lord, tribunal is to issue notice, summon to the Qazi.
Provided you file an application.
My lord.
Instead, you have taken time for further evidence. Everything will be evident from the records.
My lord, record may be called for, my lord.
Call for the record.
My lord, in the interim, my lord.
In the interim, I don't think this is the case which
In this case, link between father and grandfather also not that.
gives us confidence to grant you interim.
My lord, father evidence, my lord, how that can be rejected, my lord.
Provided he is the father.
My lord.
Provided he is the father.
What is the material to show that he is not a father? My lord? I claim, my lord. That is the full bench
Section
decision.
9, the burden is on you. You have to discharge.
My lord.
You have to
My lord,
discharge that he is the father.
Full bench judgment, my lord, in paragraph 1173, that where it is observed that when the proceeding claims that so and so my father, that should have been rebutted by any rebuttal evidence by the state. That is not done, my lord.
All right, we'll examine your records heard. Mr. A.K. Sikdar, counsel for the petition, Mr. G. Sharma, counsel appearing for the respondent number 2 and respondent 4, M.S.P. Barwa for respondent 5, Mr. G. Hazarika for respondent number 3. Stop petitioners before this court putting the opinion dated 29/12/2023 passed in FT case number FT within bracket G4 bracket close capital M/234/2018 by the learned member Foreigners Tribunal 4, Walpara, whereby the reference made by the state under the Foreigners Act 1946, was answered in affirmative in favor of the state and against the petitioner, and holding the petitioner to be a foreign national who had entered into India illegally on or after 25th of March 1971. Stop. At this stage, the court would like to examine the tribunal records before proceeding any further in the matter. Accordingly, let the tribunal records be called for. In connection with FT case number so and so from the Foreigners Tribunal 4th, Walpara, by the registry, and the matter be listed after 4 weeks along with the tribunal records. Meanwhile, the petitioner will appear before the SP border, Gwalpara, within 1 week, within 10 days from today. And upon furnishing a bail bond of rupees 10,000 with 2 local sureties of like amount, the petitioner will be permitted to remain on bail and shall not be deported out of the country without leave of this court. When the petitioner appears before the SP border, Walpara, the biometrics of the iris of both the eyes and fingerprints of both the hands of the petitioner, along with the particulars of the telephone number, contact details and residential address shall be recorded by the SP border, Walpara. Stop. The petitioner shall not move out of the territorial jurisdiction of the SP border, Walpara, without written permission. List accordingly.
May I please, Lord? But page 27 may be seen, Lord.
27.
Yes, Lord. Lordship, petitioner's parents' names are recorded in the voter list of 1966. Page 27, Lordship.
Yes.
Relevant portion, page 28. Asiruddin Dabari was my father and Asrun Bibi was my mother. Then, Lordship, next page, Lordship, page 29. My parents' names were recorded in the voter list of 1970. And thereafter, Lordship, page 31, 1979, also my parents' names were recorded. Thereafter,
You
Lordship,
show us the opinion. Where is the opinion?
Lordship, I am coming to. Lordship, kindly look at page 22. Page 22. My Lordship, electronic voter list were not considered. All the exhibited electronic voter list was not considered. That is my case, Lordship. Page 22, relevant portion of the court's tribunal's observation, Lordship. The submitted voter list are verified by OP from the election office, Dhubri, and in this regard, a verification report received from the election office, Dhubri, wherein authenticated the voter list. But all the voter lists are electronic certified copy of electoral roll. Accordingly, Lordship, these voter lists are not taken into consideration. And so far as link is concerned, Lordship, I have exhibited my ACLC admit card. Lordship is 37. Thirty-seven is my link document admit result settled position, Lordship. Page 37, and Lordship, in respect of my admit card, Lordship, court tribunal's observation is page 21.
But there is this judgment of the court that these are only certified copies.
Yes, Lord.
You have to get these documents proved.
Lordship, kindly see that here, page 22, the submitted voter list are verified by the OP from the election office.
Ah,
that was
verified in what manner? By issuing a certificate.
No, Lordship, that was sent to the election office, then they replied.
That's what I say.
Yes, Lord.
By way of a communication.
Yes,
This
Lord.
is not how documents are proved. You have to examine, you have to call these officers.
And in this, Lordship, this is the secondary, Lordship, evidence, Lordship.
Secondary evidence, provided the primary is not available.
Lordship. In this once, Lordship, 35 copies from the lawful custody, Lordship. It is normally, yeah, and Lordship, so far the Burhan Ali judgment is, they cited that by the tribunal, Lordship. That is not properly interpreted by the tribunal, Lordship. I have got the order of the Burhan Ali's order, Lordship. Wherein also it is stated that, Lordship, I am reading. Yes, sir.
Mr. Sarkar, yesterday also we inquired this aspect. How do
Lordship, can you see the
please come?
Burhan Ali judgment which was referred by the learned tribunal, paragraph
Mr. Sarkar,
paragraph 21.7.
page 26.
Page 26.
Down below, before the QR mark,
Yes, Lord.
just above the QR mark.
Yes, Lord.
How do you prove that?
Mhm.
This is the translated version of the Assamese version of certified electoral roll.
Yes, Lord.
So is it proved under the evidence that we valid document that only you download it and show it is sufficient?
Lordship, nowadays, Lordship, once for any person, Lordship, applied for the voter list, they supplied the electronic voter list, Lordship.
Then thereafter,
And
that
thereafter, Lordship, when the petitioner applied before the tribunal for verification of the report, they submitted report that they are genuine voter list,
what the
Lordship.
brother has pointed out, only when you call for the record and prove it to the officers of the concerned authority.
Lordship, in note, Lordship, in voter list, Lordship, may be seen, Lordship, in notes. This certificate, Lordship, kindly allow me to read, Lordship. This certificate is digitally signed and therefore needs no physical signature. Bottom down below, Lordship, note. Authenticity of this certificate can be verified from so and so, so and so. Certificate verification. This certificate is legally valid as per Information Technology Act 2000 and its subsequent amendments. Note itself stated, Lordship. This is legally valid. In note, Lordship, may be seen. In every voter list, Lordship, in note portion, it is mentioned. And Lordship, in Burhan Ali's judgment, Lordship, just I have submitted. Kindly allow me read two paragraphs, Lordship. Therefore, if a proceeding relies on a voter list, only a certified copy of such voter list or extract thereof would be admissible in evidence. Only certified copy of such voter list, Lordship.
Read section 76 of the Evidence Act. Kindly read section 77 first.
Lordship, this is not evidence. Lordship, in Burhan Ali's order, Lordship, section 76 also discussed.
So how a particular copy.
Lordship, kindly see, for a moment, Lordship, kindly see 21.5, 76, section 76 discussed here, Lordship. That bring us to section 70 of the 76 of the Evidence Act. Every public officer having custody of a public document, who is any person has a right to inspect, shall give that person on demand a copy of it on payment of the legal fees. Therefore, together with the certified copy written at the court of such a copy that it is a true copy of such document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies so certified shall be called certified copies. As per section 77 of the Evidence Act, such certified copies may be produced in proof of contents of the public documents or part thereof. This is very important, Lordship, 21.7. Therefore, if a proceeding relies on a voter list, only a certified copy of such voter list or extract thereof would be admissible in evidence, Lordship.
Correct.
So, Lordship, we have
But this is a
these are the
translated
certified
version.
copies, Lordship.
This is a translated version.
Yes,
not the
Lordship, these are
original public
furnished
document.
by the Lordship Election Office itself. We applied for the certified copy, they supplied the electronics, Lordship. I have not mentioned to produce the electronics. I applied for the vernacular. And note itself, voter, in every voter list, we have exhibited, Lordship.
In Nishiran Nesa's case, Lordship, these things are elaborately discussed, Lordship.
What was finally held in the judgment? Burhan Ali?
I am relying, Lordship, on 21.7, 21.7, maybe. So.
You come to 21.8
Yes, Lord.
or 21.7.
Yes, Lordship.
21.7 and 21.8.
Yes, Lordship. I have gone through the.
Then
Lordship, we had mentioned, Lordship, only a certified copy of such voter list or extract thereof would be admissible in evidence.
so ultimately the court did not consider reliance on the certified copy.
Only certified copy will be admissible, Lordship.
No, why don't you can't read one paragraph out of the entire judgment?
Yes, Lordship.
Therefore, I say you read the earlier paragraphs
Yes,
along with
Lordship.
21.7 and 8
Your Lordship, therefore, if
and 9.
Lordship, therefore, if a proceeding relies on a voter list, only a certified copy of such voter list or extract thereof would be admissible in evidence. Filing of an unsigned or unauthenticated or uncertified copy of voter list sought to be relied upon as proof of citizenship would not be admissible in evidence. Therefore, we would respectfully disagree with the view taken by the Odisha High Court. And now 21.8, Lordship. There is one more aspect. Though under section 79 of the Evidence Act, there is presumption as to genuineness of the certificate copies, provided that such document is substantially in the form and purpose to be executed in the manner directed by law in that behalf. It is in the domain that citizenship is a contentious issue insofar the state of is concerned. There are 100 corners tribunal functioning in the state of Assam, which are mandated under the law to answer reference made to them by the referral authority, that is, concert superintendent of police, as to whether the proceeding is a foreigner or not. Simultaneously, process is on or finalizing or rather updating National Register of Citizen in the state of Assam. In both process, proceedee or claimant, as the case may, primarily rely upon the voter list to prove their citizen. It is also in public domain that a large number of voters have been detected which have been suspected to be not genuine. Therefore, notwithstanding the presumption of genuineness under section 7, it would be safe for the tribunal and to the court to insist on proof of contents of such certificate by comparing the primary evidence, that is, electoral roll in original produced and testified before the tribunal or the court by the lawful custodian of the thing.
So this is the final ratio.
Lordship, normally, Lordship, once Lordship petition exhibited any electronic voter, that was verified by the tribunal.
You are trying to interpret this judgment. This judgment, ultimately the ratio is para 21.8. That tribunals are to insist on the original being produced.
My understanding is that, Lordship, once a person for 35,
You rely on some authorities. Why don't you rely on some authorities?
and Lordship, the voter list itself mentioned that, Lordship.
Mr. Counsel, this is a judgment of a division bench, coordinate bench of this court. Your reliance on the judgment in the earlier paragraphs will have to be read with the penultimate finding of the court, the ratio of the judgment.
Lordship.
The ratio of the judgment is in para 21.8.
Lordship.
Now, if you disagree with this view,
Lordship, here so my understanding is concerned, Lordship. I am once reading, Lordship. Therefore, notwithstanding the presumption of genuine under section, it would be safe for the tribunal.
Correct.
This is mentioned. It would be safe. This is not mandatory. Tribunal and the court to insist on proof of contents.
No, what is the meaning of giving an observation that it is safe for the tribunals?
Yes, Lord.
So the tribunals consider this to be an order.
Some totally are detected as post documents, some detected in the proceeding. So, Lordship, it is mentioned it would be safe for the tribunal and the court to insist on the contents of the certificate copy comparing with the primary evidence. And Lordship, these documents are verified by the office.
If you disagree with this view, you come up with contrary authorities on this.
Lordship, in judgment, Lordship, in opinion, submitted voter list are verified by office from the election office. That is verified. They are issued this.
You are harping on the same thing. This is the same facts which are considered in the Borhan Ali judgment and concluding that it is safe, that it should be verified by calling for the records. Yes, we call for the records at this stage.
I may be protected, Lord.
Protection, we are not convinced. You show us that the view of the tribunal is incorrect. Prima facie,
Lord, the problem is that, Lordship, OCT applied for the certificate before the election.
you will have to, you are the counsel,
Yes, sir.
you are supposed to build up a case and urge before the court. What has happened is already there, but what is your argument? What is your submission in support of these facts?
And Lordship, so far I have found this is not the only case, Lordship, where the digital certificate.
Have we prevented you from referring to those cases?
No, Lordship, because Lordship, this is the going on in the tribunal, Lordship. Once they are certified, they furnish the certificate to electronic document.
You point out some authorities on this.
So, in Dr. certified voter list itself, Lordship mentioned, Lordship. Lordship, in time may be granted, Lordship, at the time of hearing, I will satisfy your
We will
Lordship.
call for the records. By the
Lordship,
time the records are there, you think of some other authority. If you can convince us, we'll grant you interim time.
I established my linkage with admit card, Lordship. At this stage, Lordship.
How you have proved the admit card?
Lordship, this is case 21, maybe.
How you have proved that?
Case 21, tribunal's observation. Exhibit 1, Lordship, second paragraph, case 21. Exhibit 1 is the ACLC admit card in the name of Hazara Khatun, daughter of Asruddin Babari, and date of birth is so
You
and so.
sent a verification report.
In this regard, the Secretary of Board of Secretaries sent a verification report that the admit card given from the verification with record found genuine. This is
Whether this is proof of a document.
that is not disbelieved by the tribunal, Lordship.
No,
This document is not disbelieved, Lordship.
it is not accepted.
And so far the other grounds is concerned, Lordship, in the proceeding, Lordship, petitioner was examined as DW1. This evidence, her evidence is not at all discussed, Lordship, in the opinion.
Whose evidence?
Petitioner's evidence, Lordship. Her evidence not at all discussed, Lordship.
We are calling for the records.
So her elder brother was lordship examined. His evidence neither taken into consideration nor rejected, lordship. His elder brother's Muzamala with evidence, lordship. Two, lordship, DW2. So at this issue, also, I may be protected, lordship, and call for the records, lordship.
Is an opinion of 2022.
Yes.
And are you detained?
No.
Then heard learned counsel for the parties. Give the name. The petitioner is aggrieved by the opinion dated 4/7/2022, passed in FT, case number 2416/D/11, rendered by the learned member Foreigners Tribunal number 1, Dhubri. By the said reference, by the said opinion, the reference made by the state under the Foreigners Act 1946 was answered in affirmative and against the petitioner. So the tribunal opined that the petitioner is found to be a foreigner who had illegally entered into the territory of India from the specified territory post 25/3/1971 without any valid documents. Stop. Where it is submitted that the petitioner contested the reference by exhibiting as many as 14 exhibits and examined 3 witnesses, including herself. Stop. It is submitted that the tribunal did not consider the evidences adduced and accordingly answered the reference against the petitioner. So, at this stage, the court would like to examine the records, tribunal records. Stop. Registry, therefore, is directed to call for the tribunal records connected to FT case number 2416/D/11 from the Foreigners Tribunal number 1, Dhubri. Stop. Prayer for interim to be considered upon receipt of the tribunal records. Let the matter be listed immediately after the reopening of the court during the summer recess. We'll consider it. We have not rejected your prayer.
Lordship, I think, lordship, this is a fit case, lordship, for granting interim, lordship.
We would like to hear that this is a fit case for allowing the writ petition.
Nebulous lordship. Lordship, it is a expert opinion, my lord. And the SP border Nalbari, my lord, made an reference, my lord, against one Azmat Ali, my lord. I am Azmal Haq, my lord. And the reference has been sent to the IMDT Nalbari, my lord. Subsequently, this matter has been sent to the Borpeta, my lord. And in the reference, my lord, it is P.S. Mukalma, Lordship kindly see Annexure 1, page 22, my lord. Azmat Ali, son of Azimuddin, village Khudra Bamanbari, P.S. Mukalma, district Nalbari, my lord. And in the order, my lordship kindly see, my lord. Page 23, my lord.
Page
23, my lord.
23.
Expert order, my lord. No notice has been served upon the petitioner, my lord. And that is why he is not unaware about the case, my lord. Lordship kindly see. I am not Azmat Ali, I am Azmal Haq, my lord.
Then why are you before the court?
In pursuance of the order, my lord, I have taken into custody, my lord, on 2/9/2024, my lord.
Oh, you are taken into custody.
Lordship, on 2/9/2024, my lord.
All right, then we'll issue notice here. We'll have to issue notice here.
Lordship.
You are already in custody.
Lordship. In the meantime, I'll maybe release, my lord.
No, we can't release you like that. You're a declared foreigner. You're taking.
No, my lord, I am one Azmat Ali, I am Azmal Haq, my lord. I have no one document is here, my lord.
Have you filed an application for release?
No, my lord.
You file an application, we'll consider it. Heard, learned counsel to the parties, this writ petition is directed against the order dated 25/2/2021, passed by the learned member Foreigners Tribunal Roman 3, Borpeta, in FT case number 33 within bracket Roman 3/2019. Stop. By the said order, the tribunal passed an ex parte order holding the petitioner to be an illegal migrant.
No, petitioner, my lord. One Azmat Ali, my lord.
By the impugned order, one Ajmat Ali was held to be an illegal migrant under the provisions of Foreigners Act 1946. Stop. It is submitted by the learned counsel to the petitioner that the petitioner is Ajmal Haq,
Lord.
aged about 49 years, son of late Ajimuddin, village Pudra Bamun Bori. Post office Chatala, PS Orthebari, district Borpeta. Stop. It is submitted that the order, impugned order dated 25/02/2021, was passed in respect of one within quotes Ajmat Ali, AJMAT. Stop. It is submitted that petitioner evidently is not Ajmat Ali. However, stop. However, pursuant to the order dated 25/2/2021, the state authorities have taken the petitioner into custody and have placed him in the detention center at Gwalpara. Stop. Aggrieved, the petitioner is before this court putting to a challenge to the impugned order, putting to a challenge to the action of the respondents in detaining him at the detention center at Motia, Gwalpara, in terms of the order dated 25/02/2021, passed in FT case number 33/3 of 2019 by the learned member Foreigners Tribunal 3, Borpeta. Stop. Para, let notice issue, returnable 4 weeks. Mr. G. Sharma appears for respondent number 3 and 5 and 6.
Yes.
MSP Barua for respondent number 2. Mr. G. Sharma for respondent number 4. G. Hazarika for respondent number 4. Stop. Since the said respondents are represented by the respective councils, notices are waived. However, extra copies be furnished within a period of 1 week from today. Steps on respondent number 1 and 7 be taken by registered post as well as usual course within 1 week from today. Let the registry requisition the tribunal records in connection with so-and-so case number from so-and-so tribunal. Matter be listed after the records are received. Stop. It is provided that during the pendency of the writ petition, the petitioner shall not be deported out of the country without leave of this court.
One observation, my lord, my application may be considered, my lord. My application for release,
Where is your application?
I'll file, my lord.
You file it, we'll consider it. But you have to file it.
But and another prayer, my lord, page number 24, my lord.
24.
Not sure.
Yes.
Due to typographical mistake, my lord, name in place of Azimuddin, it is Rajuddin written, my lord. I may be allowed to correct, my.
In place of?
Rajuddin, name.
it should be Azimuddin, my lord.
This is a translation. The
Lordship.
original is all right.
Original, all right.
You point out at the time of hearing.
Lord.
You point out at the time of hearing.
Lord. Pass.
Yes, Mr. Ali.
May I please, Lord? Not the impugned judgment will order opinion will page 90.
Yes.
Now, my lord, the petitioner, my lord, exhibited the voter list of 1966, my lord, then 70, then 89 of her parents, my lord. And her brother was also there along with parents. Then she exhibited, my lord, land document where her name was muted after the death of her father, along with all brothers, my lord. Page 31, my lord. Now, the learned tribunal discarded the mutation, my lord, saying that mutation was not on the basis of title. Title was not proved, therefore mutation is bad. Mutation was not in accordance with law.
Yes.
This is the linkage certificate, my lord, and certificate issued by Gao Pansayat, my lord. Gao Pansayat secretary was also examined.
Where is that?
Page, my lord, 38, my lord. Elder brother, my lord, deposed, my lord, as DW4.
No, no. Where is the deposition?
Deposition, my lord. DW3. 59, no? Yes. DW2 Gaura was also examined, DW2 and 3. Case 74, my lord. The secretary of the government. DW5.
This was on the basis of hearsay.
My lord, it was countersigned by the video also.
But you see the evidence itself.
Yeah, my lord, all the voter list was produced before him. Case 71, my lord, deposition of the elder brother.
Where is your written?
Lordship,
In which paragraph you have mentioned about your siblings in your written statement?
written statement, my lord, case 48, my lord.
Where you have mentioned the name of your siblings or how many siblings you have? Have you mentioned?
No, my lord, it was not mentioned in,
Then it's possible you can bring someone as your elder brother.
in the land record also, my lord.
Maybe.
So may,
Where you have stated that your parent had, your father had landed property? Which paragraph? Where you have stated? In which village your father purchased that land? He was paying land revenue regularly till his death, thereafter by someone from your family or your mother. Raman, your case will come up tomorrow. We'll take it up tomorrow.
It was an ex parte order, my lord,
44, right?
44.
We'll look into it.
My lord.
Mr. Raman, be here at 10:30. 10:30, my lord. There will be some other items we do not know, but I'm grateful.
Mr. Ali, we call for the records now. What
I
else?
may have, my lord, the land records, my lord, and
Where you have mentioned that your father had.
in the WS, it has not been mentioned. I have seen, my lord.
Heard. Mr. R. Ali, learned counsel for the petitioner, Mr. G. Sharma for respondent, Home Department.
2 and 6.
Huh?
2 and 6, Lord.
2 and 6, MSP Barua for respondent 3, Mr. G. Hazarika for respondent number 5. At this stage, the court would like to examine the records. So, FT case number 122 of 2016. Wherein the opinion dated 9/6/2023 was rendered by the learned member Foreigners Tribunal number 6 for Penang. The impugned opinion had answered the reference in affirmative and in favor of the state and against the petitioner, holding the petitioner to be an illegal migrant who had entered Assam on or after 25/03/1971. Stopped being aggrieved, the present writ petition has been filed. Let the registry requisition the records and the matter be placed before the court after the records are available after 4 weeks. Prayer for interim to be considered upon perusal of the record.
Item 18 to 23 tomorrow at 10:30.
20.